Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so that we can all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Hendrick White, Pre-litigation Manager, we will be discussing being prepared for prolonged time out of the office, whether scheduled or not. Welcome back to the show, Hendrick.
Thanks for having me.
As we go forward, before we start talking about how to negotiate pre-litigation cases and the value in setting them up to help properly set reserves, as well as try and get timely resolution for certain cases, can you tell us what a pre-litigation department is, why it's important, and how it can help be a value added even for a firm that is doing catastrophic injury work?
First part of that question, what is a pre-litigation department? Pre-litigation at our firm, we have 2 paralegals, myself, an intake person, and a legal records clerk. And our job is to get the case set up, figure out who the insurances are, gathering the evidence, get everything in so that we can expeditiously try to resolve the case in a way that is cost effective for the client.
Why is it cost effective for a case to resolve in pre-litigation as opposed to going into the complaint being filed and full litigation going forward?
It's cost effective in the sense that once you file a lawsuit, the case costs are going to go up significantly, increase significantly. Mainly the costs are fairly low in pre-litigation. You may have the cost to obtain records, the occasional, maybe you need an expert report or something like that. But other than that, there's no filing fee. You're not retaining a handful of experts trying to prove different parts of the case. So in that sense, it could make more sense for the client to resolve the case in pre-litigation instead of going, all the way to trial or close to trial, that sort of thing. The other thing is time-wise as well. What we try to do is get the case into a position to settle or to figure out if it needs to go into litigation around a year. We try to get that figured out.
In that regard, from a value perspective, some people might associate pre-litigation resolution with smaller cases. Is that the case, or are there cases where there are $1 million resolutions, $1 million policies being paid and being paid efficiently in that same time frame where they're done in that 6 months to year period instead of multi-year?
Yeah, definitely. Our caseload is a range of that. Most of the cases are probably less than $500,000, most of them. But we settled a $1 million case, I think stem to stern. It was probably like 8 or 9 months on that case. And that settled for $1 million. So it comes down to the issues in the case. This case had big damages. We were able to, at first it looked like the case, there was only like $25,000 in insurance that we could recover. We were able to figure out that the defendant was actually on the clock working for a company at the time. So we were able to get a commercial policy on the hook as well. But yeah, so cost effective for the firm and cost effective for the client. Being able to resolve the case for the full policy limits above $1 million was really beneficial to that client, and definitely would like more of those type of cases in the department.
And beyond keeping the costs low, which definitely benefits the client's net, it's the timing as well. It's not getting some of the horribleness of being dragged through litigation, dealing with discovery responses, sitting for deposition, going through that stress, and just the shortened timeline.
Right, shortened timeline. Most contingency fees increase once you get to a certain point in litigation, or some I've worked at firms where as soon as you file, your fee increases too. So there's a lot of benefits to doing it on both sides for the client and for the firm.
As we tie off the benefits for early resolution, there are also benefits for a case that goes into litigation. Is that right?
Yeah. If we're unable to resolve it for what we think the value of the case is in pre-litigation, we'll have a conversation with the client. Generally, in the beginning, we have that conversation. This is what our plan is. We're going to see if it makes sense for us to resolve this in pre-litigation. If it's not, we'll move your case into litigation and introduce you to your team, litigation team of attorneys and that sort of thing.
And I think what I was trying to bring forward in a less than perfect question was how getting that information early on to an adjuster helps them set reserves properly. So there's less having to fight in litigation to get that number increased when there already was a ceiling set, as well as for the litigation team, they receive a case where the medical records are already ordered, they're in chronological order, The facts of the case are pretty well known. A demand package has already been put together, which is easy to update and turn into a mediation brief. And the efficiency from the lawyer's perspective allows the lawyer who takes that case to be on their toes instead of on their heels in litigation.
Definitely.
So those are all the benefits. Let's talk about the steps along the way in terms of doing that pre-litigation negotiation. Client comes in, the case is in essence prepared. What steps are taken as far as getting medical records, other records, and outreach to an adjuster early on to help that adjuster understand, gosh, I need to take these people and this case seriously?
That's really important. That's what I wanted to touch on. Setting the reserves just will help out when it comes time to push this into a settlement kind of phase.
We've talked about setting reserves, but we haven't defined it. What does that mean?
Setting reserve is you're telling the adjuster what your expectation is so that adjuster can he's got to budget out all his cases and set like, hey, this case is going to be 100,000. And if you don't have a conversation in some way with the adjuster in the beginning, he's just going to guess on, like, if you send your first letter is going to be your letter of rep, and you're going to say like, hey, these are our injuries. And if you don't have a conversation with that adjuster, like, these are our injuries, and I think you need to set your reserves for X amount and kind of factor in what you expect to come as far as additional kind of damages from those injuries in the future and the general damages. If you don't have a conversation with the adjuster about that, he or she will pick arbitrary number and it's going to be really low. If you just say like, our client suffered a back injury, they're going to be like, soft tissue, I'll set it for 20,000. And then you work up the case. You don't really ever talk to that adjuster throughout the first 6 months of the case. You get the evidence in, you calculate your damages, you put a demand package together, you send it over and you're like, here's a demand package for $250,000. And he's like, whoa, I have $20,000 set for this case. I'm going to offer you 15 and I got some room to wiggle. And in order to get that adjuster above his reserve that he already set, he's got to go to people above him and be like, hey, this is what I thought it was worth. And now they're telling me it's worth this. And it turns into a lot bigger hassle for everybody. And all that really needs to happen is have a continuous conversation from the start. Like, here, this is what we got. This is what we think it's going. Let's set the reserve so we don't have to do some clawbacks at the end there.
And that setting the reserves is so important. And I say that because we've had cases that we've taken over, been asked to come in and help try, where the reserves were set low early on, and it's like turning a super tanker to get the reserves changed. And we've gone to verdict on cases where the reserves were set so low that there was just no ability for the carrier to really come back, even though the defense lawyer and the adjuster knew that they were looking down the barrel of a gun.
Yeah. If you have kind of like a smaller value case that you really don't think should go into litigation, you're going to find yourself having to file, it gets assigned to an attorney. And then after maybe a round of discovery, the attorney agrees with you. And you just spend an extra 6 to 12 months on the case, racked up a bunch more cost when it's basically the same net outcome.
I cut you off in terms of defining what setting reserves is. As you're helping that adjuster with that process, you were starting to go into what you include with your initial letter of representation to help that adjuster really get a sense that it's more than just soft tissue, for example. If you have it, what else do you include with that letter of representation to help educate the adjuster?
Yeah, I understand that you may not know the extent of every injury, maybe in the first week that you get the case or in the first couple of days. So what we do, we send the letter rep, we put in the injuries that we know of, we send our letter of rep, bullet point our injuries, and tell them that we want to try to resolve this without going into litigation. We think this is a case that can be resolved without having to file a lawsuit. We don't want to put their insured through that unless we have to. And in order for us to take that route, we're going to need them to disclose the policy limits for the case to help us evaluate and expedite this claim. So we'll ask for the policy limits, any kind of evidence that they may have gotten from our client before we sign them. Like maybe our client signed a record release. And so we want to ask them to send over what they already obtained and tell them like, hey, that's, we revoked that authorization. Other than that, we also want to tie down whether their defendant was in course of scope I want to find that out right off the bat. Try to figure out all the different policies that could be in play. Is there a owner of the car different than the driver? How many insurances are kind of tied to this incident? That sort of thing.
Umbrella policies, evaluate those against underinsured policies that might be available, whether those underinsured policies are from states where things stack or don't stack. A lot of moving parts.
Yeah.
You do your due diligence with that. I assume the records come in and the other information comes in. Once the material is assembled, what do you do with it?
Yeah, so once we get everything in, we are going to start putting together a demand package. And we're looking at putting together the narrative. What's our client's story? Not just what happened, but how did this affect his life? We want to draft it in a way that is interesting to read, whether they read it or not. Who knows?
And that is one of the challenges, because what we learn from adjusters is they care less about the compelling narrative and care more about the numbers and the medical records. And at the same time, we need to write it in a way where it does communicate. And now I'm not asking questions, I'm starting to add information. We have had situations where, in example, the non-economic damages, some of the information that we've supplemented with has moved the needle. I think of a case where a fellow ended up developing cancer during the time that he had a collarbone fracture and they were unable to repair it. And adding in the information about all the vomiting that he was doing and the bones grating back and forth moved the needle to getting a full policy paid, whereas before the adjuster was getting stuck.
Right, yeah. There's the reason to do it, to write the narrative for that reason. And I think there's also a reason is this may end up in litigation, and just being able to get a narrative within a year could help out down the line. It could help out for a mediation brief later on. Just start fleshing out, like, what's the story here? What's our theme if we go to trial, that sort of thing.
I think the takeaway thematically is always do good work, because that work may be used and built on either in this case or in cases down the road as one uses it. A demand package is a template for another demand package. Demand package goes out. There's some back and forth with the adjuster. Explain how that goes forward and how one either reaches the point where, yes, there's resolution, or no, we're going to litigation.
You got to have an idea of, what do I think the value of this case is, resolving without going into litigation, because you're probably going to get more if you go in litigation, unless you got really bad facts that you'll get defense on. But besides that, you kind of want to have an idea, like, through my experience and similar cases, and maybe even looking, if it's some obscure injuries, looking at jury verdicts on Westlaw, and just trying to get an idea, like, what kind of recent kind of settlements or jury verdicts have occurred with this type of injury. You want to have that in your head. And then you also want to have a conversation with your client, fill out his or her expectation, kind of give them, like, hey, this is where I think, like, this is the low end here and this is the high end here. If we're unable to get in that zone, are you comfortable with going into litigation? And just kind of setting their expectations and getting them kind of primed for some disappointing news, because it's going to come back bad probably.
Well, and generally that is the case, right?
Yeah.
Whether it's pre-litigation, litigation, what have you. I think of a mediator who has frequently started mediation with defining settlement as arriving at a mutually disagreeable number.
Yeah, exactly.
There is that piece in terms of reaching a resolution point.
Yeah, before you submit the demand, put a number. The other conversation you want to have with the client is like, hey, we're submitting a demand for $300,000. That doesn't mean we're going to get anywhere near that number. That's just giving us some room to go back and forth with. Yeah, you really want to set the expectations and just make sure the client's comfortable and sets the goal, and you set the way to achieve that goal.
In terms of, you mentioned looking at verdicts and settlements. Do you sometimes include some of those with a demand, with a supplemental, to help educate an adjuster who is not understanding the value of a claim?
Most of the time, I kind of do that as a supplement. I don't know how successful it's been in the past. It's hard to find a really precise case, settlement, verdict that kind of fits your facts, and then find one that you're like, this is the range I was thinking as well. So it's kind of hard to like match that, and the adjusters will push back. Like, there's one injury. The case you sent us had like 5 injuries, and you have one in there, and you're trying to like extract what that value of that one injury in that case is. It's a little difficult in that sense, but every now and then it's worked. And A little funny story. I was working on a demand with one of our case managers. I think it was late last year. I asked her to get some jury verdicts, and she compiled like a handful of them. I was reading through them, trying to figure out which ones we should use. And after going through like the third one, I looked at like who the attorneys were, and it was you and Marianne. I was like, oh, well, we're going to use that one.
That's reassuring.
Yeah.
Yeah.
And that one worked. So I think it's something to use if you can find the right jury verdict, or, sometimes there's just like weird injuries that you haven't dealt with, and maybe that'll be helpful. But it's hard to line up the stars on that. Like, you could find the right injury, but it's from 1983. What is the value of that for 2023? I don't know. Or you could be like, oh, this is the right injury, but this is some weird jurisdiction. It's hard to match it, but I think it can be useful in certain cases, situations.
And I think of supplementing, because in certain ways, it's like a mediation in that there are multiple rounds of negotiation. And sometimes for another round or two, you need some additional powder. You sometimes decide, oh, well, we thought we didn't need an expert, but it appears the adjuster needs some additional material to be able to back up the number that we want the adjuster to give us. Turns out we might need to send this person to a doctor for a forensic report of some sort. Is that a tool that you sometimes use?
Yeah, and a lot of times I'll do that when the adjuster doesn't see the value of the injury, or maybe is disagreeing with our thoughts on what that injury is going to lead to in the future. So that'd be good to do it like a pre-filing kind of retention for report, and have the expert opine on a couple things that you need.
So at this point, the case either resolves, and hopefully you have a happy client because it's resolved quickly and it's resolved without the pain of litigation. And you've had the conversation so the client understands that this is the range that is appropriate, or it doesn't resolve. If it doesn't resolve, how do you tee it up to hand it off to litigation, recognizing that you are going to be in the litigation department soon? We should put some more meat on those bones. So you just finished the bar after 4 years of law school and working full time and being a father.
Yes, halfway through it.
Congrats on that.
Thank you. Yeah, I'm glad that's all behind me. But yeah, to tee it up for litigation, first have your conversation with the client, let them know, hey, these are our options. And, sometimes you may not think it's good to go into litigation. You want to have a further conversation with the client. And other times you're like, yeah, this should go into litigation. I think it's going to be better for you. And then what we do is I'll have a meeting with the litigation manager, kind of give them the facts. And this will probably happen 30 days, maybe 60 days before it's time to move the case. Like I'll put the litigation manager on notice that, hey, this is going to probably come over unless some miracle happens. So get them on board. I want the case manager to make sure that the file is nice and clean, meaning like organized, got all our evidence kind of named correctly in the file and everything's there. We don't have stuff hanging out in emails. Once the litigation manager assigns it to an attorney, have the case manager set up a meeting between everyone, the client, the new attorney, and the case manager, and have a nice, hopefully smooth pass off.
I recognize there are some other things that we should probably touch on. First, low-hanging fruit. At this point, every demand that is going out under CCP 999, the change in the law to do a policy limit demand or variant thereof, to make sure that if the case does go into litigation and there is a verdict that exceeds the policy, it's been set up nicely for the bad faith maneuver. And for those who aren't familiar with that, there is a previous episode. Just search us up on CCP 999. We'll do a link in the show notes. So that piece is something that is now policy for the pre-litigation unit, correct?
Yeah, every demand.
Then the other piece in negotiations is there are cases where sometimes adjusters just don't think that a lawyer is going to pull the trigger, meaning move it into litigation. And so sending the complaint with this is your last chance, it's drafted, or even filing the complaint and sending a 998 out, a formal policy limit demand very early in the process to set that floor. Are those tools that you also coordinate with the litigation department to make sure that you squeeze every bit out, and sometimes they wrap at that point?
Yeah, Not every time, but certain cases we'll do what we call our flag means death letter, taken from the HBO Max show. Very good show. You should watch it.
Is the show Our Flag Means Death, or is it?
Yeah, that's the name of the show. And so we borrowed the title of that show to name one of our letters, which is basically saying like, hey, you're wrong. This is why you're wrong. Kind of almost rehashing the main points of the demand in the letter. Getting a draft complaint put together by working with the attorneys in the litigation department. Get that put together and basically fire a shot over the bow and be like, hey, we're not joking around, even though you're probably thinking we're bluffing and then we're not going to file, but we are. We have it ready to go. And this will be your last chance. And we may try to use a little leverage of the insured. Maybe we'll address it to the insured and write the letter to that person, care of the adjuster, of course.
We've done this, I think, on a number of podcasts, but giving credit where credit is due, using a variant of the running with the bulls technique, Nick Rowley, Courtney Rowley. We'll also put that in the show notes. If you haven't read it, definitely buy it, read it, and use it.
So we'll do a little bit of the running with the bulls type letter. My gut feeling is a lot of the insureds, the defendants, have no idea what the insurance company is doing at this point in time. And by sending them a nice little letter about how the insurance company is being obstinate and going to drag you through litigation, and maybe you should have a conversation with the adjuster before we do this.
Yeah. One pointer, to the extent that anyone is listening to this thinking about setting up a pre-litigation unit, all of the work that the pre-litigation department is doing is overseen by an attorney in terms of green-lighting resolutions, making sure the demands, making sure the negotiation moves are all acceptable.
Yes, everything's approved by an attorney and all the work products looked at before it's gone out.
That's to avoid that uncomfortable practicing law without a license issue.
Yeah, definitely prepared, studied that outline a little bit during the bar prep.
With your knowledge base, it'll be nice to be able to turn that over to you with a full license.
Yeah, scary.
Yeah. So have we covered from a macro level the things that we need to cover so that somebody can understand why it is useful to run cases through a pre-filing settlement approach?
Yeah, I think we had all the main topics. I know a lot of firms don't use that business model, but I think it's a really good one, especially if you can find really good case managers that have pretty good writing skills. I think that's important for that position. Some paralegals, case managers are good at certain things, but you want to kind of have a writing orientated type person, especially if you're trying to pump out demand packages. And that's the goal of the pre-litigation team, is get the demand packages out. Yeah, you kind of want to focus your hiring in that skill set.
Okay. Well, thank you, Hendrick. Always nice to have you here.
Thanks for having me.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on how you approach cases like this. Like what you hear? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.